to say, if you're covered by the act, before you do anything to your voting rights laws, you have to come to the federal government and we will review what you're doing before you can do it. The reason why it's an extraordinary piece of legislation is that under our constitutional system, if a state has the power to do something, the state usually doesn't need the permission of the federal government to do it. So it's always been very controversial as to whether or not Section 5 is constitutional. Now, Section 5 has been renewed in successive occasions, recently a few years ago, and what the case was about was a municipality district out of Austin, Texas, that was challenging whether or not the act was constitutional.
Well, thank you.
Okay.
I have one more question. If you are saying that the courts are going to err on the side of liberty versus equality, and litigation would not be able to do that or bring change, which vehicle would you suggest to?
I don't know. Perhaps I should turn the question to my colleagues, but I think the work that the Leadership Conference is doing, along with our organization, is absolutely vital. But I think if I take off my litigator hat for a moment and I put sort of my scholar hat and I look at the work, for example, that Professor Stewart is doing, I think the question I would ask myself is this. When was the last time that Congress passed a truly major piece of civil rights legislation that changed the civil rights landscape? I'm not talking about passing a piece of legislation that sort of strengthened an existing one or aimed to reverse a decision by the Supreme Court, right? I'm talking about if I said that during the Reconstruction period, between 1866 and 1873, Congress passed an extraordinary number of civil rights statutes, all aimed toward giving true freedom to the slaves. And that if you think of the period between 1957 up until, say, maybe 1980 with the passage of the American Disabilities Act, we're not simply tinkering at the margins. We're basically passing civil rights statutes that aim to truly change the way we relate to one another. I'm not entirely sure that I'm optimistic that we're going to do so anytime soon or that we've done so since the ADA. So I know I'm not quite answering your question, but I don't know what the venue would be.
Thank you.
Good afternoon. My name is Joshua Taborn. I'm a double major political science and philosophy senior here at Howard. My question is for both of you. With the current path or perceived path our country is taking politically, with the new emergence of the Tea Party and the polarization of our parties, how real or how pragmatic do you think both of your causes are as far as civil rights? Being that we're entering a state that's going to be very polarized politically.
Joshua, I appreciate the question. Certainly the Leadership Conference has been around for different administrations, has worked with what we call sort of not so friendly Congresses, and perhaps we may see one in the next few weeks or months. I think time will tell. I think in an environment that is not as friendly as perhaps some may perceive the current one or the last year and a half or 2 years have been, where we've been really excited to get certain amendments in or pass legislation and get it through, two things. One, even in a more friendly environment, you still need votes. Votes still matter. And so even though we might have the majority, we still need the sign-on from our colleagues on the other side of the aisle, if you will. That's going to be increasingly more relevant if we see that, for example, Democrats are not in control in a few weeks or a year or two. So I think to answer your question, it makes us perhaps even more relevant, or makes us even makes our cause even more vital that we expand our coalition, and that might mean expanding it to groups that maybe traditionally we had not reached out to or worked together with. It might be groups that sort of politically or in certain issues are sort of maybe a little bit more right of center than we are. We are nonpartisan, but certainly many of our advocacy asks, I think, tend to be a little bit left of center, if you will. But I certainly think that while the road will be a lot steeper, it makes it that much more important for us to make sure that our alliances are a lot stronger with congressional members that don't necessarily see eye to eye with us, and it means that our coalition has to be a little bit broader. And in some ways, when I speak to my colleagues who preceded me, while it might be a little bit more adversarial at times, and perhaps more challenging and more difficult to get things through, I strongly believe that that's sort of the time to, if not get passage, then lay the foundation, lay the seeds. I think that, in many ways, when people are sort of not in power, I think your strength really is laying that foundation for when the time is ripe. And so while for example, I mentioned the End Racial Profiling Act, or, another issue that I work on is minority contracting, perhaps the time may not be right in the next year or 2 years, but what we need to do is make sure that we, have all of our ducks in a row so that when we're ready, we can see a swift passage, because that window may not be very broad. I did want to say one thing, though. We talked a little bit about the current Supreme Court, and we talked a little bit about judges. One thing that I want to highlight, many of you have read or heard that this current administration, President Obama, has seen the fewest number of federal judges appointed to the bench. And some say, well, he actually has nominated a smaller number, but I think proportionally to sort of past presidents, some of his predecessors, he's seen a lot of pushback on some federal judges that have been sitting for quite a while. Why is that important to us? It is because it's, federal judges, it's a lifetime appointment. And while the judiciary should not be political, one may debate whether or not it really is, because so many of the sort of questions that are asked of judges beforehand tend to sort of touch on their political leanings and how they might decide on a particular case. Those of you that may have watched some of the recent Supreme Court hearings of Justice Kagan will find that to be true. And certainly one thing that we do at the Leadership Conference is really try to push the lobbying effort to get some of the judges that are sort of sitting and sort of laying in wait to be confirmed, so that they can, these are judges that we like and that will have a lifetime appointment, hopefully, such that if things turn politically, these are judges whose scholarly views, and you may speak more to this, will sort of transcend what's going on politically and can actually sort of render decisions that will be with us for years. And I think that there's tremendous power in that. So that's part of our ongoing efforts, is to make sure that we see passage of some of the judges who will hopefully be on the bench even when the administration changes again and again.
Thank you.
We have one more question.
Hi, good morning. I'm John Parks. I'm a lecturer in the Afro-American Studies Department. I've got a comment and a question. The comment is that I would like to suggest that the civil rights movement or era began actually during slavery, because there are literally thousands of lawsuits for freedom that enslaved blacks and free blacks engaged in. And also that includes a number of civil rights cases. And my question has to do with, I guess you could say, the relationship between the state and the power of the state and our right to assemble. And specifically, I'm referring to, protest, where the state feels threatened. It may investigate the protesters. And so this gets into the area of what we call privacy issues. And a lot of people's personal information is either disclosed or disclosed without their consent. So how do we reconcile the power of the state versus our right to protest?
It's a tough question.
Doing the First Amendment question on you in the 14th Amendment context.
Right.
If I may try to answer the question from the perspective of when this issue finally comes to a head in the court, what will likely be the outcome? There is a reason to be optimistic, because if you're using the term state to mean not state in the federalist sense, but state in terms of government power, I think I'd be optimistic. The reason why is because I think you have a lot of justices on the court, in particular Justice Thomas, Justice Scalia. There's every evidence that Chief Justice Roberts and Alito feel the same way, who take the liberty principle very, very seriously. The idea that when faced with the question of how far may government interfere with the individual's power to express him or herself, I think there's every reason to be optimistic that chances are this court will err on the side of individual rights. If, on the other hand, you're referring to the state not in terms of general government power, but rather the states as states in the federalist system, then I think I'd be pessimistic, because this court has taken the view that the 11th Amendment, which grants state sovereign immunity to the states and prevents private lawsuits against the state, not only in federal court but also in state court, should be read so expensively as to basically virtually guarantee that these lawsuits can never occur. So I understand that there is a lot going on in this country right now with respect to government surveillance, et cetera, and when it comes to so-called national security issues, the court tends to be very, very deferential toward government power. But if you take the national security issue out of the equation, I think if you pit individual rights against state power in the view of this court, there may be good reasons to believe that the court will err on the side of individual rights.
Okay. On that note, I would like to thank everyone for coming. I would particularly like to thank our guest speakers, Professor Aderson Francois from Howard University School of Law, and also Lexer Quamie from the Leadership Conference on Civil and Human Rights.
Thank you.
If I could invoke my privilege as the introducer to have the last word, I just wanted to respond to your questions and to your point, Dr. Parks, by saying that going back to what I read initially, which was the preamble to the Constitution, and to say that our Constitution is not perfect, but it's perfectible. And so the answer to all of your questions is essentially, if things are bad, we have a complex system of government, we have a number of pressure points, legislative, litigation, and the point is to just not stop trying. Thank you very much.
I've actually been working with the leadership.
Oh, really?
Yeah. Are you involved with the project?